Perfect. So, good afternoon, everyone. I want to welcome you to our fifth in the series of our Fall Law Symposium. And today we have a very exciting topic. We have with us Fred Pinto. And Fred has been an IP technology and transactional lawyer and an entrepreneur. And he focuses on the needs of founders for over 15 years. Fred holds honor degrees in civil and common law from the University of Ottawa and graduate law degrees in international law from Leiden University and in comparative law from McGill University. Fred has been an editor and writer for leading peer-reviewed law journals, and he has lectured on IP and technology law topics at McGill University Law School, where he was named the Meredith Memorial Scholar in IP Law, at Recording Arts Canada, and for continuing legal education courses in Canada and the US. He's also been a featured speaker for leading thought leadership organizations, such as the Lord Reading Law Society and the International Economic Forum for the Americas. Fred once co-founded a music streaming venture that counted Bob Dylan amongst its shareholders, and he was named to the Canadian Advisory Committee on the GDPR, which advises Canadian Parliament on data protection and privacy matters. Over the course of his career, he's helped founders secure and enforce their rights, as well as scale and sell their businesses. And he's helped them close deals with some of the largest companies in the world, including Microsoft, Costco, Facebook, Salesforce, Disney, Verizon, Pixar, Universal Music, and many more. So it's a great honor and a pleasure to welcome Fred Pinto, who will be speaking to us today about the IA and its effect on the justice system. So welcome, Fred. Thank you so much for joining us today. And the floor is yours.
Thank you, Devorah. Really appreciate the introduction. Thank you. And thank you to everybody here who's present on the CLE today. I appreciate you all taking some time out of your busy practices to listen to me, and hopefully you get some value from it. So the title of the talk is Justice in an Age of AI. And I'm going to talk to you about the potential use of AI, so artificial intelligence, machine learning, and the use of advanced statistics to improve the legal system. And obviously, I'm sure everybody here is at least somewhat familiar with the topic of AI. Discussions around AI are often filled with fear. The emotion of fear is often very closely associated to the topic. There are many different fears. There's the fear of replacement. People fear that jobs will be replaced or that their tasks are going to be replaced. There's the grander fears of catastrophe, so the machine takeover fears. Many people, leading thinkers, have said that AI will eventually bring the end of democracy, the end of civilization. And it's not just minor people saying this. Google's own head of AI resigned over these types of fears and concerns. As lawyers, we often respond to fear with attempts to regulate or slow down a technology. I've seen this many times in my career. And a recent example of this in the context of AI is President Biden's recent executive order on AI. And you kind of see what the approach is going to be. It's largely in response to these fears and concerns. And what basically is going to happen is we're going to see the formation of new government agencies. We're going to see a new generation of laws being enforced, regulations, new instances covering the use of AI, so on and so forth. And all of that is going to be very interesting to follow. And I suspect that all democracies will follow suit in that direction. But I also want to suggest today something different. I want to suggest that there's another way to look at this entire emergent technology that is AI. And I believe that while some of these fears may be justified, what is emerging is also a radically new set of tools that can help us improve the profession significantly. And in particular, that can help us make our profession more just. So the legal profession in general is kind of resistant to change. We often see our role as preserving the status quo or interpreting the status quo. But we need to remember that the status quo is far from perfect. It comes with very significant challenges to our shared sense of justice. As laws have gotten much more complex and expensive to litigate, lawyers and judges have become very skilled at using language and using the laws for various purposes. And of course, we know that there's human nature still lives on, and all of the dark sides of human nature still live on in this profession. And I think that this is where AI can make the greatest positive impact, and that's what the talk is going to be about. So let's start first of all with what is justice. And I'm not giving you a lengthy scholarly exposition here about justice, just a very functional definition, just to make my argument clear. So very obviously, law and justice are not the same, right? The law is an instrument. We're referring to the enforceable rules in a society, the processes, whereas justice is a more general sense of how the legal and political system operates and the extent to which it embodies certain values. Now, which values is obviously up for broad debate, right? There's a lot of discussion around the tension between freedom and equality, for instance, or the tension between freedom and safety, or there's many different opinions on the role of tradition or the role of different philosophical traditions or religious traditions. And these questions pop up in many different contexts and at many different levels, and sometimes get settled legally, sometimes get settled politically, and there's no sort of full consensus on these. However, I'd argue that in the Western legal tradition, at least, there is a broad consensus on a much more limited but highly functional definition of justice around three core concepts. The first one is independence, okay? So the extent to which the group of people who make legal decisions, so mainly judges, is independent of the people with executive or political power. And this goes back to the book of Deuteronomy, Devarim, which provides for limitations on the power and possessions of kings, which is something that was very controversial. I'm sure at the time, it still is controversial today, that the power of some people should be limited. We see it in the common law emerge with the Magna Carta in 1215, that the king is not above the law. So even the king must respect the law. And so today we know this concept as the rule of law. And we see it expressed in many, many things all across our legal system. So things like judicial tenure or judicial review of government actions and so forth. So the first one is really independence, making sure that the group of people that make decisions, legal decisions, is distinct from the people with executive or political power. The second one is transparency. So the extent to which the rules, reasons, and processes of legal outcomes are clear and known by all of those who are required to follow the law in advance, okay? The extent to which we know the rules, we know the processes, we know the reasons in advance, okay? And this is mainly expressed in the obligation to write the law, and of course, also give written reasons for decisions. The problems to transparency arise when laws multiply. So when there are so many rules to respect that it becomes easy to sort of focus on some of them and not on others, or to play up some rules and play down some others. You start to see problems with transparency when the verbal skill of the legal community becomes extremely high, and where, the reasons given and the reasons underneath the decision are different. And we're going to see this in some of the data-driven literature that I'm gonna review for you today. You also see problems with transparency when there's a widening gap between infractions and enforcement. When the rules that are enforced selectively or enforced in a particular way, regardless of what the law says in the books. When any of these things happen, transparency is lost, right? And basically there, it's when the reasons disclosed for a legal outcome are different from the actual reasons, okay? Then the outcome is no longer transparent and it loses in justice. And when we talk to litigators, experienced litigators, they tend to chuckle on this issue because they recognize this in their practice, how the reasons given and the actual reasons behind the scenes are not the same. And then the third concept is the concept of fairness. So the extent to which like situations lead to like outcomes. We call it, as a profession, equality before the law, okay? So it's reflected in the right to be heard, in due process rules, and the problems to fairness basically arise when we notice that like cases are treated differently, and especially when we do not know the reasons why. So fairness and transparency work together. And my claim here, as we're going to go through the evidence-based literature, is that, we're doing okay with independence, but I believe that there are some very, very significant flaws in our current legal system when it comes to transparency and fairness that AI can help us significantly improve. So I'm going to start with a couple of very well-known examples highlighting these issues. And by the way, anybody who has any questions throughout the presentation, you can just maybe put them in the comment section. And when we go to FAQ, we'll maybe start with the questions that were put down in the comment section. And also, I'm going to give people an opportunity. You don't necessarily need to take notes of all the studies and all the stuff I refer to. I'm going to give people an opportunity to get the slides and to get the full references and the sources and references to everything I talk about in this presentation at the end, okay? So the first study I'm going to talk to you about is very famous. It's called the Refugee Roulette Study. And what it did is analyze databases of decisions on the asylum adjudication process in the US, about 400,000 total immigration cases over a 7-year period. And the analysis revealed really some amazing disparities in grant rates based on who the individual adjudicator was. So for example, in one regional office dealing with Chinese applicants, some officers granted asylum to no Chinese nationals. So if you happen to be in front of one of these adjudicators, they would systematically refuse every single one of the cases, while other officers granted asylum in as many as 68% of their cases. In another regional office, Colombian asylum applicants whose cases were adjudicated in the federal immigration court in Miami had a 5% chance of prevailing with one of the court's judges and an 88% chance of prevailing before another judge in the very same building. So the disparity that came as a result of the identity of the individual judge was 83%. Now remember, the law was the same, the rules were exactly the same, and there were no differences in the fact patterns between the different applications. Rather, what this study suggests is that the main factor in predicting case outcomes was not the letter of the law, and it was not the factual specifics of every case, but it was the identity of the individual judge. There was no equality before the law. There was no real transparency. And of course, every single decision justified itself in terms of the law, in terms of the case law, in terms of the jurisprudence, the doctrine. So lawyers are very skilled at being able to provide post hoc justifications for their decisions. But in reality, it was highly, highly biased. It really came down to the individual judge that you were in front of. Another example is studies around implicit bias, okay? So implicit bias studies work with a test called the implicit association test. It's basically a computer-based test where users have to rapidly categorize a concept with an attribute. So the concept, for example, could be male or female, and the attribute could be logical. And so what the test reveals is that there's easier pairings will lead to faster responses. So if the person taking the test associates the concept and the attribute quickly, it means that these concepts are more strongly associated in memory. It becomes easier for them to use these associations than the more difficult pairings, which takes them a little bit more time to sort of connect, okay? And so there's a very well-known study in the Notre Dame Law Review that takes a look at the difference between white and black defendants. And it showed that on the IAT, white judges pick positive adjectives much faster for white faces than they do for black faces. And then when you look at sentencing, judges who exhibit a white preference on the IAT test give harsher sentences to defendants when they're primed with black associated words, okay, rather than neutral words. And judges who exhibited a Black preference on the IAT gave less harsher sentences when they'd been primed with Black associated words rather than neutral words. So in other words, the bias went both ways, okay? If you start by being biased against whites, you will tend to be more preferable in your outcomes with white defendants, and the opposite is true if you have a bias in favor of Black people. Very interestingly, and this has become a sort of a classic finding in behavioral science, judges are overconfident about their own lack of bias. So a group of judges was asked to rate their ability to avoid racial prejudice in decision-making relative to other judges. 97% of judges placed themselves in the top half. So there was way more credit to go around than is possible. Of course, you can't have 97% of people being above average, but 97% of people are confident that they are above average in their ability to avoid bias, and that's not what the literature suggests. There's a more recent IAT study that took a look at the impact of implicit bias against Asian and Jewish defendants. This one was in the Florida Law Review. So we reviewed decisions by 239 judges and found that federal judges held strong to moderate implicit bias against both Asians and Jews as compared to Caucasians. They found them more likely to associate negative stereotypes like greedy, scheming, and dishonest.
We're supposed to be listening to a lecture.
I don't know if people are
Okay.
not.
Please mute yourself. I'm going to go find them. I'm going to
Afin
find them.
d'obtenir jugement de dossier sur un acquiescement partiel.
Guys, please make sure you're muted because some of you are coming across in the main feed. I think Deborah just found them. Okay, good. So yeah, in this study, they found that Asians and Jews were more likely associated with stereotypes like greedy, scheming, and dishonest, while Caucasians were more easily viewed as trustworthy, generous, and honest. They also imposed harsher sentences against Jewish defendants than they did against Caucasian defendants. And very interestingly, there was no difference between Democratic judges and Republican-appointed judges. So the bias seemed to be the same regardless of which party had nominated the judge. There's also a very interesting data-driven literature using case data that's emerging as well. So we have the what has been discussed very much, the hungry judge effect. So in a paper published in Nature magazine in 2011, it was found that judges were more inclined to be lenient after a meal and to be much more severe before a lunch break. So before a lunch break, when they're very hungry, they tend to be a lot more severe. After lunch, they tend to be a lot more lenient. That's a paper in Nature magazine in 2011. We also have the angry judge effect. So that's the hungry judge effect. We also have the angry judge effect. So this one's very interesting. A pair of economists at LSU looked at decisions handed down in Louisiana's juvenile courts between 1996 and 2012. They found that when LSU's the university in Louisiana State University, when LSU lost football games it was expected to win, judges, and specifically the judges who had earned their bachelor's degrees from LSU, issued harsher sentences in the week following the loss. When the team was ranked in the top 10 before losing the game, so when the team was supposed to win and they were doing very well that season, and then they lost the game, which is a bigger disappointment, kids wound up behind bars for about 2 months longer on average. When the team was not as highly ranked, so when the expectation was lower, it was a little bit more than a month, okay? So they imposed a less harsh, but still harsher sentence. So, and in this particular study, they found that the harsher sentences disproportionately affected Black defendants as well, but it was really all defendants in the weeks following a tough loss by the local football team. But it's not all negative. There's also a happy birthday judge effect. So in another study, 2 French scholars studied the effect of defendant birthdays on judicial leniency in France and the US. So they analyzed 4.2 million cases in France and about 600,000 cases in the US. In France, they found that if the defendant appeared in court on their birthday, they were 1% less likely to receive any prison time. And if they did receive prison time, it was on average 2% lower than for regular defendants, or a difference of about 27 days out of about 1,200 on average. So still quite significant on a very, very large number of cases. The same analysis in the US, in US federal court, found that there was less variability because there's stricter sentencing guidelines, which reduced judicial discretion, but there was still a significant difference in the number of days added to the sentence. So sentences are often expressed as 3 years plus 2 days, and the day component is a function of judicial discretion. And so they found that there was a 33% lower day count when the sentencing occurred on a defendant's birthday. Okay, so the portion of the sentence that went to judicial discretion, 33% lower when the sentence was given on a defendant's birthday. So it's safe to say if you're going to commit a crime, make sure you're heard after lunch, on your birthday, the day after a big win by the Montreal Canadiens. This is, of course, not the kind of legal strategy we're taught in law school or even in law firms, but the best studies suggest that this would make an outsized difference on the legal outcome. Is that fair? Is that transparent? I let you draw your own conclusions. There's also studies on the human factor relating to juries in particular. And so here there's a couple of effects. One of them is the litigator anger effect. So in a sample of 455 jury-eligible participants, it was found that the prosecutor's authentic expression of anger increased the odds of a guilty verdict. So when the litigator expresses anger in an authentic way, they are viewed as more competent, and a jury will view it as a greater expression of injustice. And so when the litigator does not do this, there's lower odds of a guilty verdict. So that's the litigator anger factor. And there's also a disgust factor that goes to the words that are chosen to describe a crime. So mock jury studies, and there's been many, many of these that have been performed, have demonstrated that people are more likely to assign guilt when the crime is described using gruesome injury. So in one study, for example, 2 groups of mock jurors were given factually identical descriptions of crimes, though in one condition, the crime was described in sterile terms, so just regular terms, and in the other, the victim was described as being brutally tortured, or her face had been obliterated beyond recognition. Jurors in the gruesome group, gruesome language group, were more likely to convict the defendant. In a similar study led by a scholar named Eduardo Vasquez, again, same thing, 2 groups of mock jurors, and again, one set of regular descriptions and one set of gruesome, grisly descriptions. Jurors meted out, gave significantly harsher punishments when words like savage and splattered were used instead of just regular words. So that's the disgust factor. So these studies suggest that legal outcomes are to a large degree a function of emotional factors rather than the accurate, transparent, fair application of the law to the facts. There's also a new approach emerging in data science when we come to analyzing legal decisions, and there are more bottom-up approaches where we analyze all of the data relating to it. So a lot of these studies are more top-down. We take a hypothesis and then we test it with respect to what the hypothesis holds. If there's a racial bias, an implicit bias, a hunger bias, an anger bias. These approaches are more bottom-up in the sense that they analyze all the data, and using machine learning and AI, we try to figure out what is the data point that will more accurately predict a legal outcome based on a large number of cases. So giving an example of this, I'm currently involved in a collaboration with Dr. Jonathan Afilalo at McGill University School of Medicine, which he has developed a machine learning tool to predict instances of heart disease using an algorithm, very similar bottom-up sort of approaches to data. And so we applied the same technology to legal cases. And what we did is we started with an experiment to sort of predict what were the factors that could predict whether or not a non-compete clause in an employment contract would be found to be enforceable or not. And so we took a look at about 60 factors in over 100 cases. And what we found is that the top predictive factors included whether the employee breached other provisions of the contract unrelated to the non-compete, whether the employer company was based inside the province or outside the province, and the number of words in the non-compete clause, with a shorter clause being more enforceable than a longer clause. Of course, it's very interesting to see that none of these factors are in any way recognized in the case law, in doctrine, or in legal theory as being relevant at all to a finding of enforcement of a non-compete, and yet they were among the most predictive factors in terms of the actual outcomes. This suggests that a lot of the theory that we go through when we try to evaluate legal cases and when we try to predict whether a case will be successful or not are very likely to be very faulty, because those are not the actual factors that lead to an actual prediction of whether a case is going to be successful or not. So what does all of this literature mean? It means that the so-called human factor in making justice, right? Human beings make justice, also makes injustice, okay? Human beings are very good at coming up with post hoc justifications and explanations for their decisions, but those are not necessarily the actual reasons why they are deciding in a particular way. So these biases often manifest themselves unconsciously or semi-consciously. I don't think, for example, that the judges would know the birthday effect, right? If there's a 1% difference, 2% difference on a defendant's birthday, it's very doubtful that the judges know that they're being more lenient on a defendant because it's their birthday. Very, very doubtful. Very, very doubtful that judges believe that when they're hungry, they're going to be more severe and more harsh in the decision. You ask judges whether that's the case, they don't believe that's the case, right? If you ask them whether or not they are in favor of, racial biases, judges will say no. 97% of them say, well, I'm above average. I'm very clearly not in favor of any kind of racial stereotyping or bias. But the data begs to differ. The data is showing us that unquestionably these biases exist, and these forms of prejudice are very often not conscious. And so, the net result of this is that people don't have a good sense. And when I say people, I mean the people that the law applies to, I include lawyers and I include judges, don't have a very good sense of the why and how of actual legal outcomes. Indeed, if the judges themselves don't know, then the people cannot know. What are the causes of this? Causes are, like I said, legal complexity, the fact that when laws get more and more complex, they become more easy to interpret in a number of different ways. And the easier they become to interpret in a number of different ways, the range of interpretability grows. When the range of interpretability grows, it becomes more easy to justify a pre-existing bias. Like I said, linguistic skill, that's what we train young lawyers to be. Don't worry about what you believe. Don't worry about anything like integrity. Just you should be able to make any case that you're paid for. And so that's what we train young lawyers to become good at, is justifying any position. And so as linguistic skill skyrockets up, it becomes very easy to justify any decision in terms of the recognized categories of the legal theory. And then, of course, human nature. These prejudices exist inside of human beings. And so if they exist inside of human beings, they will translate themselves. It is a fiction to believe that just because you've become a lawyer or just because you've become a judge, that you are no longer influenced by human nature. This body of research strongly suggests that we are just as suggestible to all the different factors of human nature than non-lawyers are. And so legal theory gets repeated and repeated and repeated as a kind of a cover-up or a mask for the real reasons behind legal outcomes. Going back to the sense of justice question, it's very clear that this hurts transparency, this hurts fairness, and I don't think the case for more justice has to be made, but I think we do have to remember what a sense of a heightened sense of justice in the legal system leads to. It leads to better cooperation among people. It leads to more avoidance of disputes. If people have a shared understanding of what's going to happen when you enter the legal system, they will be more likely to settle their disputes in advance of time, know who's right, know who's wrong. They'll be more likely to avoid. If they don't know, the more legal uncertainty there is, then the more, the party with the most means can sort of implement and influence a decision. So conversely, a lowered sense of justice that we currently have, I would argue, leads to a dilution of all of these things. And that's really bad. And then the final point is that, judicial institutions can be biased, but they can also be noisy. So bias, this relates to a distinction made in a book called Noise by Daniel Kahneman and Cass Sunstein, that looks at these issues from the lens of the legal industry and also the medical industry. Biased is when, for instance, there's a racial bias. So a bias is systematic. So it's okay if you're a Caucasian defendant, you're more likely to be to have a more lenient sentence than if you're a Black defendant. That's bias. Noisy is what you had in the refugee roulette case, where it's completely unpredictable. You go inside of the legal system, and it's not biased. It's not predictable the direction in which the decisions are going to take. You walk in, and really, depending on who the individual is, you're looking at a completely different situation. And so the legal system becomes completely chaotic and unpredictable. What can be done about this? And so I would say to date, the contribution of advanced statistics and machine learning has been to put a stronger lens on these biases, these prejudices, the lack of transparency, the lack of fairness in the legal system. That's been the first major contribution. It's already, I think, pretty well established, but it's only going to likely broaden over the course of time as these studies improve and as they are applied to more bodies of law. We are more likely to find more and more. And I think right there's already a contribution, because many judges are aware of this literature, and as they become more and more educated about this literature, we can expect that there are some improvements to be made. But if we look at overall what we can do about it, there's a range of interventions that could be thought of, and we're sort of very early in this process. And as computer technology developers, lawyers, policymakers have these discussions, we're starting to identify the range of interventions where we can improve the situation. The first one, and they fall, I'm going to go through three broad categories. The first one is human removal, okay? When we talk about the replacement problem, we're very, very worried about being replaced, but maybe in some contexts, we should be replaced, okay? So maybe removing humans from certain decisions would make the rendering of those decisions more fair, cheaper, and faster. I'm thinking of a type of decision here that is very, very simple, that revolves around 2 or 3 factors that are known and that are objective. Most likely, the human discretion element that we're putting in is simply a place where prejudice and bias can sort of enter the equation. And so just as an example here, I'm thinking of drivers who get their driver's permit suspended and having to go in front of court. And I'm using this example because one of the lawyers I used to work with was doing these files pretty much every day, and spend hours and hours and hours in court, billing thousands and thousands of dollars on this, just to go in front of a judge for 3-4 minutes. And the judge, okay, when somebody's driver's license is suspended, they can be given an authorization still to drive because it's necessary for their job, okay? So you just have to say, okay, this is my job, this is why it's necessary, rubber stamp decision. Could AI render those decisions cheaper, faster, and with less prejudice than human beings? Again, it's an open discussion. The second broad category is enhancing human awareness, okay? So basically making humans more aware of the data, okay? So this can come in many different forms. We could issue, for instance, in a particular body of law, predictability scores, okay? So we can take a look at the data points that relate to a particular legal situation, and this could apply to any body of law, and we can give, based on the data, a predictability score. What are the actual odds of success of a case with this data profile? and then what happens if you change some of these factors, okay? So giving predictability scores to lawyers so that lawyers have a better sense of the likelihood of a positive outcome or a negative outcome in front of a case, okay? Another example of this would be giving judges a bias score, okay? So if you're in a body of law where there is a lot of bias, okay, where the data has identified a lot of bias, perhaps giving judges a bias score in particular cases will make them more aware of the situation, and then they can sort of self-correct, right? Because the evidence shows that the vast majority of judges do not want to be biased. They end up being biased unconsciously. And so a bias score could make judges aware of the types of bias that exist in this particular body of law, and then they can sort of self-correct and make sure that they're not making a decision based on one of these biases. And then another potential tool that could be developed here in terms of enhancing human awareness would be, what would an objective judgment say? So in other words, each of these bodies of law that we have has a theoretical version of how cases are supposed to be decided, right? We'll have our three-pronged test. We'll have our how different terms are supposed to be interpreted, okay? We could develop a tool where an AI engine would render, we'd enter all the data about a particular case. What does the judge AI say about this case? And again, it could be used as an awareness point for the judge. This is not the human removal tool. It's an awareness tool for the judge. The judge becomes aware of what the AI believes is the objective decision in this particular case, and then they can sort of decide, you know, if they want to detract from that. But then the whole exercise becomes more transparent and becomes more conscious rather than unconscious. So that would be the second type of intervention. The first one was the human removal. The second one is enhancing human awareness. The third one would be enhancing human scrutiny. So we can take these kinds of bias scores or objective judgment scores, and we can incorporate them in appellate and review standards, okay? So for instance, if a bias score for a particular case is extremely high, it's an 89 percentile bias score, we can now impose on an appellate court to have to put more scrutiny on that particular case. Why? Because there's a high chance that there was bias behind the decision. So we can sort of combine the AI tools that give us a data profile on a particular case. We could combine that with certain regulatory thresholds, review and appellate thresholds, so that certain cases above certain thresholds would be mandated to be reviewed and scrutinized more closely. So those are the three types of interventions that are currently being worked on, that are currently being looked at by different professionals in the space. To kind of conclude just the presentation aspect of this, and then I'm curious to see if anybody has any questions. Personally, if you ask me which type of solution I have a preference for, I would say probably the second one, the awareness solutions. They would require no legislative change. They would maintain legal professionals as the interpreters and implementers, but simply with better eyesight. So we'd not be talking about removal, just like a pair of glasses could not see on its own. They simply make a human being see better and see more things. I think the awareness, and I think overall, there are many people in the legal industry that would like to be less biased, would like to know a little bit more about the decisions, why they're making certain determinations. Certainly when it comes to deciders, I think the awareness tools could be something very interesting, and that our profession could really benefit from in terms of enhancing justice. It's important also to remember that even if mistakes are made by our eventual AI-powered tools, let's remember that the standard that we're comparing those mistakes to is not a perfect standard. It's the status quo. And the status quo is far from perfect, as I've just shown you. It's replete with injustice. And so what we should look for is progress and improvement, not perfection. And then let's also remember that very much in the spirit of the executive order on AI of President Biden's, we can bind these activities. They can be regulated. The legal space is a space that is quite easy to bind from an AI perspective. We can block AIs from having access to certain databases. We can block AIs from making certain decisions quite easily. And so let's remember that there's no takeover of the legal system if we don't allow it to happen from a regulatory perspective. Certain decisions simply have to go through the legal system. And so these activities can be bounded and regulated by the legal profession, and certainly they should be. We're very, very early in this process. I thank you all for listening. But the paths forward, I want to stress, are becoming more and more clear as technology evolves and as more conversations take place between, again, practicing attorneys, AI developers, policymakers, and judges. I'm putting the slides together with all the sources and references I've referred to in this talk. If you're interested, or if you're interested in collaborating with our Law and AI project as well, you can send me an email. I'm going to write down my email in the comment boxes, and just let me know, and we can send you the presentation with all the sources and references, and we can talk about how to potentially collaborate. I want to thank you very much for your time.
Well, thank you very much. And I guess we're going to go to questions now. Do you want to do questions? Yeah, go ahead.
I have okay. When you're trying to get the discretion removed from judges, are you going to impair the ability of a lawyer to come up with a more risky or a new line of questioning or contesting an action that, for example, at one point, I think it was beyond argument that a mother is going to get custody of their child. I don't know about today, but years ago. I handled a case where I won custody for the father based on a very reasonable, what I found. Would this AI saying your predictability, would that deter a lawyer from taking on a more risky case or making a more risky argument?
So that's a good question. It's the legal creativity, or the unforeseen situation, right? And whether or not AI would block us into a particular way of making decisions. So first of all, when we're looking at judicial discretion, the only avenue where this question would pose itself would be the human removal avenue, right? Where you take a particular type of decision and you say, okay, now the judge effectively has to make a decision based like this, right? The technology would make a decision based on the objective factors. So number one, first of all, I don't see this as being a very likely avenue where changes are going to be made. I think most likely it's going to be tools for judges and tools for lawyers. So in other words, the human being will still be there, okay? It's going to be more like a pair of glasses or a VR headset, but the human being is still there, okay? So you'll still be able to make those arguments. And how much those arguments will influence them will be ultimately be a factor of their human discretion, right? So, but in those instances where the only cases where I see the human removal being potentially interesting is if we all agree as a society that these are the only three factors that should lead to a decision, right? And it's a black and white rubber stamp type of decision making, where the question then becomes, why would we allow? So I'll give you an example of that. Okay, in this book, it's right here, Noise. It's a fantastic book by Daniel Kahneman, Nobel Prize winning psychologist, and they review in the medical space. Okay, because the medical industry is a little bit more advanced than we are. They're more science driven. They're more science, but they went through a big transition between what Dr. Afilalo calls between eminence-based to evidence-based medicine, okay? Eminence-based was, what does the eminent doctor think, okay? And it ruffled a lot of egos. And so in the study that Kahneman cites in Noise, what they did is this. They took a certain number of doctors, okay, that posed certain diagnoses, okay? And they turned the doctors, they tried to understand how the doctor made decisions. And in understanding how the doctor made decisions, they turned the doctors into a simplified model of themselves, okay? So let's say they take you, Stanley, like, okay, how does Stanley make decisions? And they look at the 3-4 operations that you tend to make, and now they create a model of Stanley, right? And so then they took a certain number of cases and they presented them to the real doctors, the human doctors, versus to the simplified model of the doctors. Which group do you think gave more accurate diagnoses?
Group of doctors.
It was the simplified model of the doctors.
Yep.
The simplified model of the person was actually more accurate than the person, which is crazy. And Kahneman says, he writes that that the doctors tended to explain when they would detract from what their simplified models decide. They tended to explain why they detracted from it in the language of subtlety. He said, well, you know, it's subtle. In this case, there's a subtle difference. And he said, but in reality, what the study shows is that the subtlety is wasted. In reality, the subtlety just makes you less accurate, not more accurate. Now, there is a difference in legal cases versus medical cases. In medical cases, you have a black and white line. In legal cases, you don't. It's much more human. It's much more multifaceted. It's much more uncertain. But I think as a profession, you know, we certainly tell each other that certain decisions have to be made objectively based on the 3-pronged factor and so forth. But I think we all know that's not how decisions are actually made. The question is that then becomes, well, how are they actually made? And that's when we see all these biases and prejudice and so forth. But to really answer your question the more specific way, I think the direction that this is taking is more in the form of tools for lawyers, tools for judges, but that the human being element will still remain there making the decision. Yeah.
If I may, the effect of stare decisis and the effect of legislation indicating stare decisis can easily be still avoided by any articulate lawyer or judge.
Absolutely.
So which way do you go? How will it be?
100%.
How will it become practical?
Yeah.
That's-
Very, very interesting. So stare decisis is the explanation, right? It becomes like the explanation, or what we can call the post hoc justification. Like once you've decided what you want to decide, you go backwards in the precedents and connect the dots, right? And it's, every lawyer knows this. Like we take a look at a case, what do we want to prove? And then we look at the case law, and then we sort of reconstruct the case law in this, right?
There's always
That's right.
two sides.
That's
Yeah.
right. And what this data driven approach does is it completely does not look at any of the reasons, does not look at reasons. It looks at inputs and outputs. It looks at the objective characteristics of a case and then whether or not the case was successful or not. It's binary. It only looks at the objective characteristics of a case, gender of the participants or the lawyers, the racial profile. You can then say, like, have they made this argument? Have they made that argument? The existence of this fact, the existence of that fact. Did this happen before this, or did it happen after this? So you break down cases into these tiny little objective markers, and then you look at the outcome. And because it's based on the idea that we don't really know the reasons why we make certain decisions. And we think we do. Like all of legal theory is just us telling each other what we think we make decisions based on. But then the data comes in and says, okay, what's really going on here? Take a look. We're just telling from a pure data perspective. When we did the enforcement of the non-compete case, the most predictive factors were unconnected to the legal theory, completely unconnected. But these are the factors that would actually allow you to make a more predictive determination of a case. And so that's how the sort of evidence-based version of law will go, is by completely neglecting all of the reasons that people give for how they've gotten from point A to point B. We just look at point A and point B.
But I mean, from a practical point of view, will it be introduced by way of legislation and backed up by judicial committal, or will it be will it slip in by way of cases after cases. And how do we
Yeah.
how do we expect it to arrive at a practical effect, have a practical effect in our
I
practice?
think it's going to be all of these things. It's very hard to predict at this point. I think if you take the Biden approach, it's going to be top down. It's going to be regulated by government agencies. There are going to be laws. There are going to be regulations. So that's one stream. The
That's
other,
expensive.
yeah, and there's very expensive, very expensive. Yes. Whether or not I think the core discussion is how will it make our legal system more just. Whether it'll make our legal system more just or not, up for grabs and up for debate. But I think another stream is going to be the emergence of tools. And what I like with the emergence of tools is that it doesn't require a top-down approach, doesn't require legislative change, doesn't require new regulations. It's just a new tool that individual administrations can decide on a case-by-case basis. I've already discussed some of these tools with judges. They're very interested in having these tools as long as they are well constructed, as long as they are reliable, as long as they are transparent, as long as we could really understand what it does, right? As long as it's not a black box. They're very interested in having this information because most judges I've talked to they're very, very much in good faith. They want to render more fair decisions. They don't want to be biased. But there is no way to really know whether or not you're biased. You can't look at yourself from the outside. And a lot of them are overworked and they've got a lot of cases. They've got to decide very quickly. And so this would just be like another tool that could hopefully make their jobs easier and also allow them to render more fair decisions.
Thank you.
Removal of okay, I have a question here. Do you have a comment about the removal of Sam Altman as CEO of ChatGPT? Was it related to his advancement of making a godlike AI tool? I don't think I'm the best person to speculate on that. I have read a few articles about it. Ultimately, I don't know. I know that so there's a lot of things happening here, right? OpenAI got purchased by Microsoft. Microsoft is looking to sort of ingest OpenAI into its own AI. I don't know if you saw Elon Musk tweeted that Microsoft intends to spend about $40 billion this year developing general artificial intelligence and rolling it out across all kinds of new products. So they're definitely looking to be the major player. So how much are they behind this? Don't know. From what I heard, it was a board dispute, and there was a faction inside of the board that did not like the fact that Sam Altman seemed to be going in a certain direction related to general artificial intelligence. We don't have all the information about it, so I think anything I would say beyond this would be purely speculative. But I also saw a lot of discussion online about how this shows how founders can be kicked out of their companies by investors after investors take over, and how generally when that happens, the company tends to not perform as well. Founder-run companies tend to be more successful than non-founder based companies. So there is a lot going on there. I'm not fully sure, but I am going to be following it with a lot of interest. Thanks for the question.
I'll just ask before we leave this issue, what I was concerned about is the dichotomy between having this open AI and have it come to a point where the machine controls us and we cannot control the machine. And I consider this to be very dangerous.
Yeah, so that's the runaway AI hypothesis, or the AI sort of like becomes unhinged and we can no longer control it. That's behind a lot of the regulation right now. They are requiring AI companies to disclose what they do, disclose how they do it, disclose what databases they have access to, and so forth. It's an unanswerable question at this point. What can happen? I have a very much a wait and see approach to these things. I think it's easier to fear that scenario than it is for that scenario to actually emerge, if that makes sense. I mean, this fear it's the iRobot fear. It's been in science fiction forever. This idea that the robot takeover, right? So we've had this fear, and yeah, general artificial intelligence could go in that direction. But a couple of things on that point. So first of all, it's interesting to see in the context of OpenAI that they're now fighting for board control. So as brilliant as the general AI is, it doesn't seem to be able to govern itself. Still needs human beings to make decisions about itself. But there's also the point where I think there's a risk of anthropomorphizing these technologies and imputing on these technologies agency. So we'll think of like, even when we make sentences about it, we're like, the AI is going to take over and do this and do that. We express it in the language of what a biological agent with desires, with fears, with a survival instinct would do. But that's not my sense of what these technologies are. I don't know that they are self-driven. I don't know that they have a survival instinct. I don't know that they have desires. I don't know that they have a desire for power. I think these are all concepts that make sense in the context of biological creatures with our lengthy evolutionary history. The other thing is, interestingly, that I heard Elon Musk say, he says, one of the acid tests to see how intelligent these tools are is, can they make new physics? Can they make new physics? What he means by make new physics is, can they come up with a radically new concept of how the physical world operates? He goes, because human beings can. We have done it, right? So if AI is not able to do that, if AI is not able to give us a radically new understanding of how the physical world operates, then it's inferior to us in a very fundamental way. And so I think that the fear is definitely there. I think we should definitely be aware of it and mindful of it, and I think we are. But I think it can also be overstated in these respects. So I think what's actually going on is a lot more complex, a lot more tricky. It operates in much more in a contextual fashion. So the impact of AI will be very different in very different contexts. And I think it's hard for us to wrap our heads around that. It's easier to think of like AI takeover, the iRobot movie with Will Smith. It's like, right, it's easier to jump to that conclusion. But I think it's much trickier. And also much more positive in a lot of ways, because this is just one example of how it can help us improve the human condition. But there are many, many others in many other fields as well. So I see it as a major opportunity to improve the human condition. And of course, we have to be careful, and we're going to be in for some surprises along the way.
Thank you.
Thank you. Any other questions?
Unmute yourself and go.
Again, I put my email address there if you're interested. If you want the slides with the sources and references, if you want to stay in touch, this is my email address, so you can stay in touch anytime.
Where?
In the comment section. So it's in the little meeting chat. So it's fpinto@pintolegal.ca.
Okay, is that it for today, Fred?
That is it for today, unless there are
Okay.
any more questions.
Okay, so thank you so much for your fascinating presentation. I enjoyed it immensely. The part that I really enjoyed as just a regular civilian is the emotions that affect, I guess, judges, and the angry and the hungry and the birthday stuff was really, really fascinating. And thank you so much for this presentation today. Thank you for making time for your busy schedule to share this with us. And AI is an emerging area in our lives, whether we like it or not. It's going to be advancing towards us. So I guess becoming more aware of its risk and as well as its benefits, and where we can improve society using it, it would be a great thing. So thank you very much for joining us today, everyone. And remember, next week, same time, same place. Thanks, everyone. Have a wonderful
Thank you,
afternoon.
everyone.
Thank you.
Bye-bye. Stay safe, everyone. Bye-bye.
Yes.
Thank you.